Firstly, I would like to welcome you all, and especially our panelists who are present here. Each one of them, whom I've known personally, and I'm very excited to hear from them and ask more about their area of practice and questions, which I'm sure you all want to hear. Their responses would be very, very useful for each and every one of you, especially for people who are planning to make a career in international arbitration. So I'll keep the format of this session very simple. We'll be asking questions to each and every panelist, and we'll hear from them. And once we have heard from all of them, we will keep it open for all of you to ask any questions if you have. The total time would be 90 minutes, and we'll try to finish in time. So my request is that all of you please keep it on mute. And if at all there is any disturbance, I request my panelists to please tell me if I'm not clear or if I'm not audible. So I'd like to start with Bhushan. Bhushan, you have pursued your LLM at two leading universities like CIDS, Geneva, and Harvard University. What tips do you have for young lawyers who want to pursue LLM into such prestigious institutions for their masters in law?
Thanks, Tariq. And well, first off, thank you very much for having me here. It's a privilege, really, to be speaking to this audience of bright young students and the opportunity to actually share insights from my journey so far. I'll try to keep it short so that we have maximum time possible for questions and discussion. Well, to begin, the wish list on admission committees is relatively easy to decipher and frankly not very long, at least as long as one's applying from law school straight off. And we're talking about things like, good grades in law school, some extra co-curricular activities, stuff like publications, internships, other kinds of academic involvement, like serving as research assistants to profs and such. Now, all of this, I'm sure you're intimately familiar with, so there's not much insight to be had there. And the issue, to my mind, really becomes, what if you don't have good grades? And does that scuttle your prospects? What if, in the wish list, you only tick off one or two? How does that place you in terms of your LLM application? So what I propose to do here would be to offer, let's say, a paradigm of thinking about the issue. In my view, admissions committees, usually assess applications on two axes. That is demonstrable academic excellence and demonstrable interest in one or more areas of law. Now, here's where it becomes interesting. And it's useful to distinguish between the various LLM programs out there. There are some that are specialized. I'm thinking like the MIDS in Geneva, which focus on international dispute settlement, mostly international arbitration, a bit of WTO litigation, disputes before the ICJ, ITLOS and such. And then there are the Harvards or Oxfords of the world, which offer a more general program, albeit with a slight degree of specialization in terms of courses offered. Now, the more specialized LLMs get, I suggest, the more they're amenable to looking beyond just general academic performance in law school and more the focus on demonstrable interest. And if you've done well in, say, stuff like the WISMOOT or arbitration internships, and these could be with domestic law firms, and increasingly, to my delight, with international ones, I routinely come across Indian law students working with, while in law school, interning with firms abroad, and things like publications and so forth. The more you do that, the more it enhances your chances. So for programs like Harvard, the focus remains, I think, primarily, at least for applicants straight out of law school, on academic achievements. Now, it's worth bearing in mind that even like the general, and I dare say more prestigious programs, have differing emphasis and like to distinguish themselves from one another. There is, in some senses, competition amongst those universities also. So for example, one can safely say that Oxford is famously grade obsessed, Cambridge less so. Yale focuses more on your potential as a legal academic. Harvard is more concerned with practice, leadership. So I should perhaps conclude, because I have one eye on the clock and I'm round about the fourth minute. Should probably conclude saying that an often overlooked factor is recommendation letters. And I say conclude because at least I overlooked it back in law school. And as you make your way through law school, work with practitioners during internships, serve as RAs to profs in your university and beyond, it's difficult to overstate the importance that these fellow travelers have on your LLM application. The more prominent in their field and the longer and better they know you, from a professional standpoint, that is, the better your prospects are. And well, I wouldn't lose heart if you didn't score high on that checklist I mentioned a few moments back. And it's arguable that you'd be well advised to, at least from a recruitment standpoint, apply for an LLM after getting a few years of experience under your belt. And that gives you more runway to redesign your career, and perhaps most importantly, give you opportunities even if you don't have excellent academics for any reason. Ultimately, it's different strokes for different folks. There's always a way to better your admission prospects if you don't get it right the first time in law school. And of course, please feel free to reach out if you want to have a more in-depth discussion. I'm always happy to chat.
Thank you. Thank you so much, Bhushan. That was very useful. And I must tell you that most of the practitioners have signed in today. The participants are not law students only. I see a majority of lawyers actually who are currently practicing and perhaps are looking forward, to make a career in international arbitration or to work with firms such as yours, you all are working in. Now coming to you, Shanelle, you've worked in Dubai, you've worked in London. Both, of course, are the hubs of international arbitration, very famous hubs, and dream destination for many people to work, especially for arbitration practitioners. So what has been your experience working in these two jurisdictions? And can you tell us, for lawyers, young lawyers, or even lawyers who are, have been working here for a while, what would you suggest if they want to, make a career in these jurisdictions? What would be your advice to them?
Thank you, Tariq, and thank you for having me here today, and thank you to the IAMC for organizing this. I'm hoping we can give some useful insights. If nothing else, just tell our stories. In terms of my experience in Dubai and London, I think they're quite different jurisdictions, but everybody's experience really is quite personal. I can tell you the difference that I found between the two. From my perspective, I find London a little bit faster in pace than Dubai. Not to say Dubai is not fast, but I find London slightly faster. And I also think there's again, from my experience, there was a little difference in the kind of work. So I found Dubai to be more construction infrastructure focused. I mean, the kind of arbitrations that you usually get. London, on the other hand, I think you get a good mix of commercial investment and construction. But then this also depends on the kind of firm that you're in. Obviously, there are firms where their entire practice is construction focused, or their entire practice is, investment or PIL focus. So it depends. But these are the main differences that I saw. In terms of pros for me, I thought Dubai was obviously the close proximity to home helped. You got into a flight and you were home in 3 hours. So that was one pro. That doesn't exist in London. It obviously takes longer. In terms of suggestions for young lawyers, I think that there really is no magic formula. I think it's hard to get a job outside your home country in any event. But there are a couple of ways that I think one can go about this. One is obviously the most obvious way. You see there's a vacancy, a firm is looking, you apply. That's the most obvious way. But I'd say that's the least likely way for a foreign lawyer to get a position in a firm that's not in your home jurisdiction, basically. So the second way, which is what I employed, at least when I was in doing my LLM, is that you identify the firms that you want to work at. Then you do a little bit of research on the partners. I was jurisdiction or agnostic or location agnostic. I was, willing to do international arbitration, and it didn't really matter in which jurisdiction. And so like I had created a list. I did research on the partners and figured out, which ones are most likely to be interested in somebody like me with my profile, with my background. And then you write to them and hope you can get a conversation or an interview. And obviously they have to be looking, all of those things have to fall into place. So there's a little bit of a luck element involved. And a third way you could obviously do it is networking events. I struggled a little bit with this myself when I first started at Georgetown. I don't know about others think, but this was not the culture I was used to, where you just go and start talking to people who you don't know. I've now learned to appreciate that there's a real value in that. It obviously, you have to know what you're going to say. You have to think, you have to say something sensible enough to leave a good impression. There's also the risk of doing too much of that, in which case it might be counterproductive and have the opposite effect. So it has to be just right. But that's a third way of doing it. So these are my 3 suggestions to get a position, but I'm sure the others might have more tips on this.
Thank you so much, Shanelle. That was very useful, especially the part wherein you said that, it's important to know your profile and who would be interested in such a profile. I think that's very, good takeaway that we have today. So coming to you, Chintan, you have studied in some of the top universities in the world, and you've earned yourself a doctorate from Cambridge. My question to you is, how does one benefit from an LLM in studying in a foreign university? That's the first part of the question. And how one can make the correct choice regarding the postgraduate course curriculum as well as the university to reap the maximum benefits for themselves, especially if they are looking to make a career in international arbitration.
So to begin with, thank you, Tariq, and to the IAMC for hosting this event. It's a real pleasure to be sharing the stage with friends and colleagues. So delighted to be here. Let me start with the first part of your question, which is the benefit of an LLM to a career in international arbitration. And I'll start with the obvious proposition, which is that it isn't necessary either to have an LLM or, for that matter, of course, a PhD in order to pursue a very successful career in international arbitration. I know of many people, more so from yesteryear, but even people, younger lawyers from today, who have very lucrative and thriving practices, who have neither an LLM nor a PhD. So you don't have to have it. But having an LLM, perhaps, less so a PhD, but anyway, also having a PhD can be helpful. And it can be helpful in a couple of different ways. The first way in which it can be helpful is to establish a sense of comfort with foreign law firms. Because particularly, coming from India, foreign law firms may not necessarily be familiar with all Indian universities. I mean, in 2023, they probably do know the top 5 or 10 Indian universities because they're familiar with them. But if you look beyond those, even though you might have excellent grades, excellent academic credentials, they may not actually know very much about them. And the fact that you have an LLM from a leading international university gives them a sense of assurance. It gives them a sense of comfort. And that applies regardless of which university or LLM is from, as long as it's from a prominent enough university for it to be well recognized, regardless of whether or not it's in an international arbitration hub. So that applies wherever you do your LLM, as long as it's a well-regarded university. Now, there are some advantages that apply, in particular, if you do your LLM at a university which is in an international arbitration hub, such as in London and Paris and Geneva and so on. And those are as follows. The first is that you have professors coming in typically from the big arbitration law firms coming to teach you. And so you have instant access to those people. You can speak to them right away. They may be marking your papers, but they'll at least be teaching you in class, and you'll get to interact with them from the outset. That's a bit harder in places that are not in international arbitration hubs. For example, I wouldn't describe Cambridge, Massachusetts, or New Haven, Connecticut as international arbitration hubs. So it's harder to find that in those sorts of places, even though the universities that they host are very prestigious. The second is that you can become part of the ecosystem, as it were, quite swiftly. There are a large number of arbitration events that take place. Just before the start of this panel, we were joking about the fact that there seem to be arbitration weeks almost every other week. That is the reality. So if you're keen and you're interested, and if you live for a year in London or Paris or Geneva, in all likelihood, you will have the opportunity to attend at least 20 events during the course of the year, if you keep your eye out for them. The third point that I'd make is that it naturally makes it easier to get a job if you are pursuing an LLM at an international arbitration hub. And the reason for that is something that I think Shanelle has already alluded to, which is that it isn't actually particularly straightforward to move jurisdiction. I think people acknowledge this. I mean, even though it's increasingly common, of course, for a lawyer to study in one jurisdiction and then to work in another, an overwhelming majority of lawyers across the world will work in their own jurisdiction. And so the first question that someone that's interviewing you from a law firm will ask you is, if you've not moved jurisdiction already, if you're applying from India, why is it that you want to come here? Why is it that you wouldn't take what would obviously look like the more straightforward route, which is to continue to live in the jurisdiction that you've lived for the last 20 to 25 years? And the answer to that question is much simpler. In fact, it may result in the question not being asked at all. If you're already there, if you're already in the jurisdiction, you've done a master's there, you're familiar with the ecosystem there, and so on. Now, a little bit about courses without taking too much time. I'm going to say two things which might sound contradictory, but which I think can be simultaneously true. The first is that it will help your job prospects, at least marginally. I don't want to overstate this, if you pursue arbitration-related courses. So whether that's arbitration courses per se, commercial arbitration, investment arbitration, etc., or courses, substantive law courses that may be relevant to arbitration, private law courses, so contract law, commercial remedies, things like that. I think that's helpful. It can help at least marginally. Having said that, at least my view is that your first priority should be to take courses that you genuinely enjoy. That's for the most part what I did. And I have no regrets about doing it. And it meant me taking courses that had nothing to do with arbitration. Some courses that had an association with arbitration because I was genuinely interested, but other courses that had absolutely nothing to do with arbitration. And I didn't regret that choice, both because it's very simple. If there's a course that you're interested in, you typically do well in it. If you're less interested in it, it reflects in your results in any event. And because it's a unique experience to do an LLM, you only do it once, and you want to make the most of it. So you do need to balance sort of both of those factors. And the ideal situation is, of course, if you do 4 courses that are arbitration related and which you enjoy, that is the best situation to be in. But that rarely happens, I would suggest.
Thank you very much, Chintan. I think that was very, very useful, especially when you mentioned that, especially if you're doing an LLM or your any degree from a established hub of arbitration, you get to see people who are already experts in arbitration from different law firms and even barristers, and they are the ones you get to interact with one-on-one. And that's where you have a very good chance of connecting to them and leaving a good impression, and perhaps you may end up getting a job in the firm they were associated with. So thank you very much, Chintan, for your inputs. Now coming to you, Arun. Arun, that after the COVID-19, we saw that technology has been playing a very important role. And, we see that a lot of tech disputes are also happening. And there has been a discussion about role of arbitration in resolving these tech disputes. Since you are one of those few people I know who is an expert in tech disputes, and you've been doing these matters for a while, I want to understand from you 2 things. One is, what is the potential of arbitration in these kind of disputes and resolving tech disputes. And the second thing is, for anybody who's present today and who would like to make a career or probably, make a name in tech disputes, what kind of courses, what kind of, what are the things, skill set that you think is required for them? We would like to hear from you.
Sure. Can you hear me, firstly? Is it all clear? Yeah. Thank you all for inviting me to be part of this really, enjoyable panel. I'm learning along the way as well, so I'm glad about that. You asked me this question, and in typical fashion, I threw the question to ChatGPT just before we started. It produced a very long essay, and I decided that is not probably what the guys in the audience want to hear. So I'm going to come at it from my own experience, which I think probably will be more beneficial. So by way of background, unlike my other august panelists, I don't have a master's degree or multiple masters or PhDs. I do, however, have an engineering degree, and then I decided to do law. So the sweet spot of technology and also construction is what I do day to day, and something I enjoy doing. Now, to answer your first question, around what's the potential for tech disputes, I think one needs to take a step back when you answer that question and understand what is it you're being asked to answer. It's technology disputes that we're being asked. You ask me what it's about. And one then goes to the technology sector, which is at the moment, I think, $11 or $12 trillion economy globally, growing year on year. So it's just like every other big corporate landscape. It's a large economy, and there are multiple players in that economy, and therefore multiple contracts, different types of contracts, and therefore scope for multiple high value disputes. So there is enough disputes everywhere, but more so in the tech industry. So it's not necessarily unique in any which sense as to whether there are disputes there or not. There's a large scope of tech disputes being resolved through arbitration. More importantly, through what I call online dispute resolution. It's not what I coined, it's a commonly used term, wherein a lot of companies, particularly tech companies, who do not tend to wish to spend too much on disputes, they try and go through the online portals of dispute resolution where everything is done online. You don't necessarily have a full-blown, hearing stretching over 2 months in London or someplace. It's all done virtually. It's more efficient. Of course, it caters for particular types of disputes, but that kind of dispute resolution has been around for some time, even well before COVID. So I feel it's more that mainstream arbitration is just adopting aspects of online dispute resolution that existed well before. So it's nothing new. There's a lot of scope for tech disputes be it in arbitration or in courts. I mean, in the UK, in the high courts, it's called the Technology and Construction Division. So the word technology is in there, and this has been there for many years. It's nothing new. Where I think there is scope for significant growth is around new technology. And that is where I feel this particular audience is probably more, familiar with, as well as probably more useful in those type of disputes because they understand the technology. They just don't come at it from a high level perspective. And that is where I feel, to answer your second question around what skills you need, I feel like there are every other CV that you see, as Chintan says and as Bhushan says, you need to do arbitration courses if you want to become an arbitration lawyer. You go to any university, you get an arbitration-based course. That's great. But the way to differentiate yourself, I feel personally, for the future, is you also do technology-related courses. There's the separate aspect of whether you're interested or not. I fully agree, Chintan. You no point doing something if you're not interested. But think about it. $12 trillion economy. Everybody is chasing the technological world. Therefore, every law firm is chasing that pie of the market. So that's where the growth is. That's where law firms are hiring. That is where they want to see more lawyers get into. So don't ignore that. When you go to university, you get courses on AI, on technology, on blockchain, do it. Because it'll become ubiquitous in a few years that this technology is what we use every day, like automobiles, for example. And secondly, don't just rely on your universities for these courses. There are multiple courses available online, be it from Oxford, Harvard, any of these, well-regarded names that have been mentioned on this course. They offer a lot of online courses. Oxford, for example, does one purely on AI. They give you a certification at the end. It's worth doing it. Okay, it's a bit of money, but it's far less than doing a full degree. And it gives you some sort of, I would say, boost over others. And I would also say, just remember that India is a huge part of that technology economy. You're already there. So don't just keep looking outside and thinking, oh yeah, I need to go to Harvard, Switzerland, wherever. Yes, you can go there. That's great, and do it. It'll be hypocritical of me to say, don't go out when I myself am out. But if you're students in India and a university there, if you go to Bangalore, Bombay, wherever, and join some of these IT companies or large tech companies, understand what they're going through from a legal department perspective, get that sort of internships under your belt. I think that adds a lot of value to both university applications and in the future for a career application. So those are I hope I answered the question, but those are my views.
Thank you, Arun. I think you did answer the question, and you gave us a lot of clarity also. In fact, I was reading somewhere that ChatGPT and AI in general is going to replace, is going to take a lot of jobs of lawyers. So I'm quite worried, and I need to, perhaps take some.
I didn't repeat the answer from ChatGPT, so I hope that gives you some comfort.
All right. So, but thank you very much. I think it was very useful, and I completely believe that technology will play a very important role in times to come. And coming to you, Shouvik, thank you very much. And we wanted to ask you two things. One is that you've worked in two important jurisdictions, both UK and US. So firstly, I wanted to understand from you if one has to make a choice, in terms of, I'm not sure if there'll be a choice because, it's difficult to get in both these jurisdictions. But if at all one has to make a choice to pursue a career in, arbitration in these two jurisdictions, which one would you recommend, and which one do you think is more open to Indian lawyers and, to accepting Indian lawyers in firms, etc.? So I want to hear your views on that.
Thanks, Tariq, and thanks to everyone else for a really great conversation so far. As Arun said, I think I'm learning a lot from you guys as well. So thank you. I'll start by saying, if you just look around at the panelists here, there's, I think, 4 of us sitting in London right now and 1 of us in Dubai. And it may be because Tariq selected us, so there's some selection bias here, but a lot of us also went to universities in the US, but then decided, or fate decided for us not to practice there. So I think there is an answer there. So I'm going to tell you why the UK over the US, and I'll give you 3 reasons. The first is logistics. This is very boring. It's basically immigration laws. It's much more difficult to, even if you go to university in the US, to land a permanency of sorts there, not because you won't get job offers. Even if you get a job offer, it's down to the H-1B lottery system. If you are at all familiar with the tech sector, you have heard about the H-1B lottery and the travails Indians have with the H-1B system through the tech sector, but the same visa application is what lawyers would have to go through. My own personal story is I started in the US, I went to law school there, and I was very confident I'm going to start working at a US law firm. I had an offer, everything was great, I was about to start, and then I didn't get it through the lottery. So that's how I ended up in the UK. And to go to the second part of the question, which is openness, the immigration system was much easier here to stick around. So I've stayed here for close to 8 years now, and it started to feel a bit like a second home. So there is that aspect. And I think in general, in addition to the lawyers in London you're seeing on this call, there are a large number of international arbitration lawyers from India, from Indian law schools, who are based in London and in the UK market, same in Dubai, same in Singapore. You'll see fewer, you will see some, but you will see fewer in the US. In the US, it's either you were really lucky and you got through the lottery, so you're there, Or you got lucky in another way, which is in matters of the heart, and you married someone who can get you that permanency in the US. To give you an anecdote, at my wedding after law school, which was right after I graduated, and I was just sitting there wondering, am I not going to have a job because my visa didn't come through? One of my friends from law school who attended the wedding said, wow, you really married for love, because there are no immigration benefits here at all. So, there's something to keep in mind, which, as a student, you don't think so much about, because if you get admission, you're going to get a student visa, you're going to get to go there. But what happens after that differs from country to country. In the US, you can work after your master's or JD or whatever degree you want in the US, in the legal field for 1 year afterwards, which is under this thing called OPT. If you're in the sciences, you get a bit more time. But after that 1 year, you need to go through this lottery. And it's just something that's a bit more precarious than it needs to be. So on that basis, I think the UK feels more open. Two other quick points to close it out. Also, the kind of practice that you would have in the US as an arbitration lawyer is, I don't want to say more limited, it's a very rich market. There's so many arbitrations going on there, and it's a very prestigious market as well. But if you just take a look at the kinds of profiles and the kinds of cases coming out of the US, it has more of a Latin America focus. So if you have a leg up there, if you know Spanish, if you know Portuguese, if you can do the Brazil market, basically do South America, Central America. There's a lot of cases there, and there's a lot of work there. Indian students usually, lots of language skills. People will be continuously impressed by, wow, you speak so many languages, and it's basically the 3 you were speaking your whole life anyway. But unfortunately, those are not the languages you will need for the arbitrations going on in the US. In the UK, it's a much more diverse. Personally, my practice has been much more diverse. I have done cases that have Latin America focus, but those are not the only cases I have done. It's a much more geographically broad market in my view, and it's because it's a more historical hub of arbitration in some ways. English law you'll find written into contracts all over the world. And then the final thing, I think both Shanelle and Arun just touched on in a way. Yes, Dubai is closer to India, and London is not as close as Singapore or some other places, but it's still closer. To me, as someone who lived in the US for 8 years, I find living in London gives me more flexibility to be close to home, not just as a personal thing, but also in terms of your business, in terms of the kind of work you do. I do a fair amount of cases related to India. I find that Indian clients are much more comfortable with a firm in London. There's just some level of familiarity there. And also a lot of exciting things are happening in India, and people are, for the reasons Arun was saying, and that is a focus market for a lot of firms. And that focus and growth is happening out of the UK, out of Singapore, out of Dubai. It's not necessarily happening out of the US. So that's...
Thank you, Shouvik. No, that was very, very helpful. And I'm sure after hearing you, many of us would only focus on London and UK, not the other jurisdictions, because various compelling reasons given by you. I'll come back to you, Bhushan. And so, your profile, as you know, I'm very fond of, the practice areas and the jurisdictions you have worked in. Perhaps one of the only few lawyers that I know who have worked in 6 jurisdictions. And I think perhaps the first lawyer to work in Korea. And I was very excited to know when you told me that, that's also a place where there's a lot of scope for lawyers. So what would be your, suggestions to lawyers who are willing to work, in jurisdictions which are not heard of, these unheard of jurisdictions, which otherwise have a lot of potential. So what would be your advice, and what would you like? Would you like to share your experience with us briefly?
Sure. Timer on. Well, it's obviously not an easy answer. If one thinks, what are you, a common law at a stretch, but essentially Indian law trained lawyer doing private practice in Korea, which is civil law based, where there isn't any chance, unlike the UK and US, to cross-qualify. What are you doing there, right? And honestly, I get this question all the time. And Fortunately, unfortunately, I'm getting less of it nowadays because there are far more number of lawyers nowadays in Korea than there were when I joined back in 2016. So perhaps the why is more important than the how. And perhaps the learnings in Korea could be applied elsewhere. I think international arbitration is, for better or worse, seen to be concentrated in maybe 3 or 4 cities in the world. And that has a lot to do with just the way the community is organized, who gets seen, who gets heard, who writes in a language that's consumed globally. And perhaps more importantly, the issue to my mind is not why Korea, but why not Korea? Why not Tokyo? Why not Shanghai? These are all very large markets. Why not, for that matter, places like Hong Kong? Now, if you just sort of pull up like the list of, the largest economies, you'll see that most of them are not common law jurisdictions. And so it's obvious to my mind that there are disputes that arise there. They need arbitration lawyers. And so maybe I should just start with why I went to Korea in the first place. So when I was doing the MIDS program, I actually planned to do the PhD at Graduate Institute, with a supervisor who was a prof at the Graduate Institute, very well known, very accomplished arbitrator and academic. To my surprise, he discouraged me from doing the PhD, saying that I was far too young, not old, to spend more time in law school than I already had. I was 23 at the time. And so his recommendation was that I better sort of focus on practicing international arbitration before exploring it academically. And in a conversation that didn't even last 15 minutes, he mentioned that the best way of doing that, in his view, and a view that I now share, is to join a busy. And I say busy because arbitration suffers from the strange phenomena where folks publicly talk a lot about it in conference and such, but do a little, don't do as much as you would think if one's exposure was limited to just conferences. And so the idea was, according to him, to join a busy practice with the important qualifier that it should be in a non-native English-speaking country. Idea being that this would afford you opportunities that were simply not available in places like the US, UK, Singapore. And that advice I took far too seriously. Seriously, at least to my benefit. And I applied everywhere. So I mean everywhere. So Colombia, Dr. Zuleta's office, Montreal, Moscow, a lot of oil and gas work there, Tokyo, Seoul, Shanghai. Ultimately got a few offers, went for Korea, because the firm that offered me a job there at the time had more than 35 full-time fee earners. And just for some perspective, I had worked with Quinn Emanuel in Paris and Debevoise in London before that for a very brief while. They didn't even have a third of that number, maybe a fourth, maybe a fifth sometimes, 7, 8 member teams. Of course, a lot has changed there since then. But 35 full-time fee earners doing nothing but national arbitration. You would think maybe, the pay is lower and therefore they can afford to hire more people. But shockingly, the pay is sort of big law, New York, effectively, if you take into everything, including cost of living. And so it wasn't cheap, but just that they had so much work coming their way because Korea is primarily an export-driven economy. And so every transaction is an international transaction. Every dispute is an international dispute. Most of it goes to arbitration. And the crew that I ran with co-founded Peter and Kim, which is now GAR 16. Last I checked. The practice that I went with was GAR 30 a few years before I joined. During my time was GAR 30 to 40, so very counterintuitive. My time's almost up. So maybe I should very briefly cover the how. And that's fairly easy. Firms in Korea are very open to international applicants, and pretty much every large practice is co-headed by a foreign lawyer. It's mostly a matter of reaching out with persistency and tenacity for opportunities. They could be just internships. If one does well, they very often do translate to full-time associate positions. LLMs would help, but not necessary. More important would be prior experience in international arbitration and very good writing skills. Familiarity with Korean and the culture, so watch Korean drama does help. And all of that is just to get in. To stay in and do well needs an extraordinary work ethic. And as I'm sure you're aware, that's not just the case with Korean law firms, but also with Northeast Asia in general, including Japan. I think my time's up. I should pause here, perhaps. But again, I'm more than happy to discuss further. Please feel free to reach out.
Thank you so much, Bhushan. That was very interesting, especially the Korean drama. I'll take some suggestions from you, and probably, because I don't have a master's, so I think the only place open for me would be Korea. So coming to you, Shanelle, you worked with some of the leading firms in the world. In Dubai, you worked with Tamimi. Now you're working with Mahale, with Gary Bond. Can you just tell us what is it that these firms look for in a CV or in the covering letter when they're hiring or when somebody is applying?
Sure. I mean, I think this varies firm to firm, but there's some constants. I would say for foreign hires, the thing that, in my experience, people most look for is some solid work experience in your home country. I'd say it's harder to get a job straight out of university. It's not impossible, but I'd say it's harder. I know maybe one person who's got a job, right out of after their LLB. In a foreign law firm. They also look for obviously good university, good grades. Like Chintan said, at least the foreign law firms now know the top 10 universities, maybe even the top 15 universities in India. They also understand the difference in the grading systems more or less. And some firms put more emphasis on grades than others. But if your grades are average or above average, you could kind of cure that by some really good work experience. Then it also kind of depends on who's looking at your CV. For instance, I look at CVs for the Indian applicants that apply for our internship program, and I put more emphasis on cover letters. I mean, obviously, I look at your CV and I see what you've done and all of those things. But there are, say, 10 people who worked in a top law firm in India with good grades, good university, and then I like to look at your cover letter to see what's your story. Why do you want to do this? So when you do write a cover letter, I'd say think about the message that you put in. Where have you come from? Why? What have you done previously? How are you going to transfer those skills to this particular job? Why do you want to make this move? Like Chintan said, why do you want to do this firm, this particular job? What are you looking for? What are you looking to achieve eventually? So all of those things interest me. And I think that one can tell if your cover letter is just generic and you just change the name. So I'd say I personally look for something different when I look at a cover letter. Some people obviously, like I said, change the names and then sometimes forget to change the names, which is bad. And that brings me to my last point, which is ensure that your cover letter and your CV are perfect. There are no typos, no spelling mistakes, no issues as such, because that gives off a really bad impression. I think this, I don't need to say this, but it's an obvious thing. But you'll be surprised at the number of people that send CVs, cover letters, cover emails with such glaring mistakes that you've already made a decision saying no. If this person didn't bother to at least check or proofread before sending, then they're not going to do a good job, in the long run. And then also my last point, and this is, we get a lot of CVs from around the world and a lot from India, and we have this habit of know your audience, basically, is what I'd say. When you get a cover letter, it's a lot of respected ma'am, so respected so and so, whatever. There's a cultural difference there. And I was once asked, actually, is this regular? Like, do people usually write like this? Do they usually, address emails like this in India? And I said, yeah, this is pretty usual. So, know that outside of India, it's usually just the person says, yeah, Mr. So and so, whatever, not respected ma'am, not respected so, or if you're writing to a committee in general, so to the hiring committee, whatever. So keep those small things in mind. But I guess you learn that over the years. When I first started applying, I was pretty formal myself. I've shared some of that over the years. So that's another thing that when people call me, that's another thing that I say.
Thank you, Shanelle. That's very, very helpful. And I think, it's very important not to make mistakes if you want to get noticed. Chintan, coming to you, you are the only barrister that we have in this panel, and you're with the Brick Court Chamber in UK. Now, what would be your advice to someone who aspires to become a barrister in London and join a chamber?
Tariq, I could go on and on about this, but I'll keep it relatively brief, and we can come back in the Q&A round. So the first thing that I'd say is that, as with all good things in life, there's no such thing as instant gratification. So this is think of it as a 3 to 4 year process at the minimum, if you're keen on joining the bar. I mean, it's probably close to that even if you want to join a law firm, but that's a minimum if you want to join the bar. And the reason for that is that the application process is quite involved. It involves the following stages. You first put in a written application. If that's progress, then you move on to an interview. If you move past the interview, then you do what's called a mini pupillage, which is basically an internship, usually of a week. It might be a bit less. If you pass that stage, then there is at least 1 or possibly 2 further rounds of interview to get what's called pupillage. If you pass that stage and you receive an offer of pupillage, then you're offered pupillage that day to commence 2 years or 1.5 years thereafter. So you've been through all of this, which has probably taken you a year and a half to get through all of this. And the day that you receive an offer for pupillage, you're told that you can start your pupillage 1.5 years thereafter. So you wait out the 1.5 years, start your pupillage 1.5 years thereafter, and do what is effectively, not entirely accurate to describe it this way, but as shorthand, what is effectively a 1-year interview. You do a 1-year interview, and at the end of that 1 year, it's then determined by the committee in the relevant chambers whether or not you're taken on as a tenant. And it's at that stage, ultimately, that you know whether you're, in quotes, a barrister within that chambers, or whether you have to explore other opportunities. Now, as I've said, what makes that process challenging is 2 things. Number 1, the fact that it's time consuming. It takes a long while. But number 2, of course, the fact that it's an exit test. It's not an entry test. Getting into, for example, a top law school in India is an entry test, right? Now you have to sit for the CLAT. But once you get into a national law school or an ALSAR, you're pretty much guaranteed that you'll have a degree from National Law School or an ALSAR. You won't be in a situation, you're unlikely to be in a situation where 5 years on, you don't have anything and you don't have a degree. The risk here is that having been through the whole process, you may still not get a place in chambers. And so I want to emphasize the risks involved. It helps. Now, in terms of what helps and what makes a difference, it helps naturally to have studied in the UK, to have done a master's or a BCL in the UK. I don't want to hide from the reality that there is now a bit of a qualifications arms race to get to the bar. So a large number of candidates, myself included, had PhDs at the time that they did their pupillage. Many people have had both PhDs and work experience in a law firm before they applied to do pupillage. The last point that I would make, and of course we can come back to this in Q&A, is that at every stage that I described, everything that you did previously is essentially forgotten. That is, when you put in your written application, your grades matter, of course, your recommendations matter, etc. But as soon as you move to the next stage, which is the interview, all that matters is the interview. You may be the topper from your university, you may have the finest recommendation, but that's irrelevant. All that matters is what you've done at that particular stage. And I think, in fact, I mean, my personal view is that that's the best way of assessing things, because once you've seen someone in person, then why would you go back to their paper application, right? Unless you had reason to. So that also makes the process somewhat trying, because you can't rest on your laurels. You can't rely on the fact that you're a gold medalist from the university, etc., because that's only going to take you through stage one, but doesn't really benefit you going forward. But I'll leave it there.
Thank you. Thank you so much, Chintan. Coming to you, Arun, you've worked in Middle East for a while, and you've been there for a long time, actually, and you know the market pretty well. There are many people who are now looking at exploring opportunities in the Middle Eastern region. What would be your advice to people who are looking, and how is it as a place to work? We want to hear your views.
Sure. Maybe I just start by answering that question with saying, what is the Middle East? Because I'm sometimes surprised people have images of it, myself included, before I moved. Until I came here, I realized it's very different. It is because I stay in Dubai, which is part of the UAE, and then there are neighboring countries which are part of the what they call the Gulf Cooperation Council, such as Saudi, Qatar, Bahrain, etc. Cumulatively, in terms of pure reserves of wealth, primarily based out of the oil reserves they had, these countries have more than trillions and trillions of dollars in reserves. But for the longest time, the expenditure, the spending was primarily concentrated in countries like the UAE, not necessarily the regional countries. But that has changed, I would say, in the last 10 years, 10, maybe 20 years, where countries like Saudi are starting to finally flex their muscle. And it is some muscle because they've got $3 trillion being spent on what they call the Vision 2030, which is a vision wherein they're building literally new cities in Saudis from the sand, literally from the sand up. And these cities are I would say, small countries in many parts of the world. So this is no mean feat. And there's a lot of spending, a lot of work going on. So that is what is driving a lot of interest in the Middle East globally, because it's one of those few areas of growth in the world. India obviously is a different and similar story, but for different reasons. But Middle East, that's the reason the world is focusing on it so much. Now, in terms of the legal practice, what do you do in the Middle East? I already mentioned, the oil and gas obviously is what the Middle East has always been known for. That continues to remain a big part of work. And since I do a lot of construction disputes, that will be a great way if anyone here is interested in construction disputes or construction law. Honestly, I think globally, this is one of the best places you can be practicing in that field. Not UK, despite what the others on the panel might say, or they seem to be nodding, so I take that as concurrence. It's not the UK, it's not the US, it's not all these nice countries that you hear of traditionally. It's the Middle East, where if you want to do a construction law front end, what I call front end, which is drafting contracts or doing disputes, this is a great place to do it. Having said that, the Vision 2030 for Saudi, Vision 2020, and the next vision for UAE and all these countries is diversification away from oil and gas. They don't want to be seen as fossil fuel countries alone. And a large part of money is being invested in technology, in general financial hubs, free zones where a lot of foreign banks, foreign private equity investors, and so on are setting up shop. So they want to diversify and become more of the traditional economies that not just an oil and gas economy. So that is where I feel if someone isn't interested in construction, there is still scope, because you can be a commercial disputes lawyer, or as I said, a tech lawyer, tech disputes, and you'll still find there's scope. Yes, I would say the market in that sense is a bit more nascent than London, USA, etc. But bear in mind that those jurisdictions have been doing this kind of stuff for hundreds of years. The Middle East is, I would say, 10, 20 years. And if you're here at this time or anytime soon, you have the first mover advantage, because it takes some time to get used to the jurisdiction, not just get used to the heat, which I've thankfully now gotten used to, but the laws, the way things work, the way clients are, and so on. So it's a great time to be looking in the Middle East if you decide to, pursue a career here in this region. Now, in terms of, is there scope for Indian lawyers, which is, I think, what most of this audience wants to hear, I would say yes. I wouldn't say no. I would say yes, because there are people here who have moved straight from India, who have managed to become partners here in law firms, including international law firms. I didn't move straight from India, so I'm not one of them, but there are others here. So because of the affinity and proximity, as many of them mentioned, between India and places like UAE, there is a lot of flow of people and a flow of talent. And a lot of Indian firms are looking to set up shop here or have set up shop here, as they have in Singapore as well. So, if you're not necessarily in a foreign law firm, you're in an Indian law firm, remember that they're also looking at these markets, these nearby markets to India to set up shop. So that could be one other way you enter the market. But even otherwise, if you do wish to pursue a career in the Middle East, it is possible if you're an Indian qualified lawyer. I will caveat that because I think maybe Chintan mentioned it, is if you're looking at particularly international law firms who are either from the US or the UK, there would be a natural affinity for them to look at people with a UK qualification or a US qualification, depending on which type of firm. So if you do end up, say, in London, you're studying there, you find that, hold on, the market there is very competitive because the training contracts are not there, etc. If you're joining a law firm, that is. Remember that the Middle East, many of these international law firms have started to offer training contracts, and it's been going on for some time now, Clifford Chance included. So these training contracts are where you become a trainee based out of Dubai, but you're still getting a UK qualification. You're still being trained by Clifford Chance or an Al-Novi or any of these other firms. And it's an alternative, which many people are unaware of, if you're not from the region. So bear that in mind if you're finishing up your degrees and you're looking to apply for something in this region. Lastly, I'll just conclude by, I think Shanelle mentioned it, but then she did, I think, have a brief stint in the Middle East. Yes, it is slow paced. I can't deny that. It's not as fast paced as London, but then again, I feel, having been here this long, there are some charms to all that. And there are, different aspects and facets of this place that people may end up liking. As one of my clients said, it is, I would say, one of the more advanced cities of India. If you look around, you'll be amazed at the number of South Asians here. So there are those advantages of being somewhere in the Middle East. And as I said, construction and all this money being poured in, if you're in those sectors, there is a lot of scope to grow.
Thank you so much, Arun. That was very helpful. Shouvik, last question to you, and then we'll take one or two questions from the audience. I know we are running against the clock. Shouvik, you have done your JD from Yale Law School. How was your experience, and how is it distinct from a bachelor's degree in law in India or a foreign LLM? Would you advise the participants to do a JD to increase their hiring chances by leading global law firms instead of doing their BLLB from India, the regular course that we do?
So thanks, Tariq. I think my answer will be somewhat like Chintan's, in that if I wouldn't go into doing a JD if your ultimate goal is to do arbitration and you're based in India. I ended up doing that and ended up in arbitration not through any intention of my own. I went to do an undergrad in the US, which had nothing to do with law. And then I decided to apply to law school in the US. And I had these notions that I would get to stick around there if as a 16, 17-year-old, I knew I wanted to do law. That is the most circuitous path you can imagine, because you have to do a 4-year undergrad degree, then you have this 3-year JD degree. At the end of those 7 years, you find out that you're not getting a lottery to stay in that country, and you're only qualified in that country. So you now have to go find the world for a job, and you're not qualified in your home country anymore because you never went to law school there. So I think short answer is don't do that. However, if for some reason you think your goal is to work in the US, or you have some way of staying there without having to worry about immigration hassles, the JD itself is great. You get to meet lots of great people. It can be, depending on the law school you go to, it can be very stressful. But if you've gone to law school in India, law schools in general are meant to be that. It's a first law degree. Everyone there has done an undergrad, but they've never done law. So it's pretty competitive, but it's good, and you can take classes in all kinds of things. I didn't go in thinking I wanted to do arbitration. I did a couple of courses in international law and arbitration. I was focused on US law, and thought that would be what my career would be, doing US domestic litigation, but it's a transferable skill. So the JD itself, the educational experience was great. Practically, if that is something that you are choosing to do because you want to do law, I don't think I would recommend it very highly. It's a really long-term investment with unclear payoff at the end. Wow.
Thank you so much. Thank you, Shouvik. I think pretty much you have covered the questions. Now we'll take 1 or 2 questions from the audience, and if somebody would like to unmute, I don't know if they're able to. There are some questions I see on the chat box. But if anybody would like to unmute and say something.
Good evening, may I?
Yes, please.
Good evening to everyone on the panel. I'm a final year law student, and I actually would quickly like to ask a 2-fold question. I've made notes as to how I could use this last year before I graduate, say take certification courses, get internships. So firstly, I'd like to ask if there's anything that would that you could help me understand what I could work on in my final year. And secondly, would it be recommended that one works in India for a few 2-3 years to get a solid foundation? And then what could be the prospects to work in either the UAE or the UK?
Thank you so much. Who would like to take it? Chintan, would you like to?
Sure, happy to answer at least part of it, and then I'll leave the rest to others. I mean, it really depends on your own circumstances. I'll speak about my own experience. I didn't work in India after completing my law degree. I did a master's straight away, and then found a job after completing my postgraduate studies, after doing a PhD, etc. I can see an argument for having some post-qualification work experience in India, because I think it's well known that having some PQE in India improves the prospects of getting a good LLM degree abroad. So you may look at, if you take things one step at a time, you may first think of doing a PQE at a good Indian law firm with the view of getting a good LLM at a foreign university, and then consider at the next stage how to get a job at a good law firm. So I can see logically sort of, that sequence of events playing itself out. Equally, if you think that the prospects of getting, if you have good prospects of getting an LLM right after you finish, then I don't see the downside of applying right now, doing the LLM, and then taking some of the steps that we've just discussed with a view to getting a job at an international law firm, if that's what you're aiming to do.
Anybody else would like to add? Shanelle, Shouvik, anyone?
Good evening, everyone. May I?
I think, who's that? Is that Shanelle or somebody else?
This is Vishala.
Vishala, just 1 second. I think one of the panelists wanted to answer the previous question. You can just ask after that, please.
Sure.
I think Vijay wanted to ask. Vishala.
Yeah. Good evening, everyone. I did my engineering in computer science and LLB and master's in intellectual property rights and PG diploma from Nalsar University in cyber crimes. I actually wanted to make a career in arbitration in international level. Currently, I'm practicing in High Court at Hyderabad, which I'm holding around 8 years of experience. I'm doing it independently. So I just wanted good suggestions. Like I wanted to make a career and to want some firm for a few years. And again, I wanted to return back to my home country. So I need some suggestions for that.
Thank you. Arun, would you like to answer this?
Sure. I think, Vishala, the word international arbitration, the word international in it, everyone just assumes it's London, Paris, Dubai, Singapore, wherever. I don't think that's necessarily the case. I think what my suggestion to you would be, you already have a very unique set of degrees and skills, which is engineering and law. I say that because I don't say that in any kind of boastful manner. I think it is unique. So, I think you would be better off building on that. Join somewhere like IAMC. I'm sure Tariq and his team will be able to give you some insights, because you don't need to take 10 steps ahead when one step ahead might open the doors for you and get you into this field. And then you start exploring it. As I said, there's also online dispute resolution forums, which basically they deal with everything on the papers as far as they can. And they do smaller disputes. A large part of it is consumer or technology based. So you could explore some of those options and get empaneled as arbitrators with them, because they're always on the lookout for people like yourselves. So I think sitting in Hyderabad, there's a lot you can already do. You don't necessarily need to go abroad. I mean, if you want to go abroad for other reasons, that's different. I can't really comment on that. But just based on what you've told, I think there's a lot you can already be doing. And from what I can say, you want to get into international or arbitration in general. And I would approach it from this tech side and all the IP disputes that you've done and so on. Use that as your calling card and try and get empaneled with some of these institutions.
Thank you. Thank you so much, Arun.
Thank you.
I think we have a very special participant, Mr. Vikram Pusarela, senior advocate, who's also our co-chair. Sir, we would love to hear your question.
Can you hear me, Tariq? Can you hear me? Can you hear me, Tariq?
Yes, sir. We can hear you.
First of all, I wanted to thank you and all the panelists for being so candid and spoke their experiences so nicely. I really wish I was 20 years younger. I would have definitely made some different inroads in what I want to do in life. But having said that, I would love to know, in terms of international arbitration, since you all come from different jurisdictions, each one of the panelists, what are the kind of opportunities you all are seeing in India, and for all those young people and the people who are trying to do international arbitration like me, is the hope that India is picking up in a manner that international arbitrations are catching up from this part of the country. I'll be very happy to hear from you.
Shouvik, why don't you answer that question, if you don't mind?
Sure. So I think, as I was saying, in the last few years, a large part of my own practice has been cases that arise out of India. And for the reasons Arun was saying, and otherwise, industrially, India is a big power player now, and that obviously relates and leads to lots of disputes. We've seen big disputes covered in the news. We've seen in the airline sector. We've seen both Indigo and Go First go through big international arbitrations. We've seen big arbitrations related to the government of India and Reliance Industries. And these are just the ones that make the news. There are a large number of arbitrations going on. We know that SIAC arbitrations, for example, not most of them, I think the largest percentage comes from India disputes, but it's not just at the Singapore Arbitration Center. We do lots of LCIA arbitrations, ICC arbitrations, and even ad hoc arbitrations for Indian clients. And I just think this is a really large market. And along the lines that Arun was saying, you don't need to be coming to London or Dubai or Singapore to be involved in any of these arbitrations. For the most part, not always. Even when we at King & Spalding are acting in these arbitrations, we are acting alongside co-counsel from excellent firms in India with really thriving international arbitration practices, and alongside really senior advocates and really good counsel, all from India. So these opportunities for India-based arbitration are not, all outside of India. It's really big and thriving in India, and that's where the locus of it is.
Thank you, Shouvik. We'll just take last two questions. I think there are a lot of people have raised their hand, but you can always reach out later on to the speakers. Devang, you wanted to ask a question?
Yes, good evening, everyone. This is a Drashti Gaur from Gujarat. Panel, I have completed my LLB and LLM in the business law, master's in business law from the Gujarat. I just want to ask one question. If I want to go for mediation, so in which course I have to choose particularly for mediation? I just want to continue my practice in Gujarat, in India only. So may I know?
Okay. So the fireside chat was on international arbitration, but anybody who would like to answer the question on mediation?
I can give it a go,
Sure.
Tarek, if it helps.
Yes, please.
I've recently been accredited as a mediator. I did a course with a foreign body called the ADR Center. There are 2 or 3 well-recognized global bodies that administer mediation courses. So if you want to get into the world of mediation, it is a good time to consider it. CEDR, C-E-D-R, is the other one from the UK. They're very well regarded. But I'm sure IAMC, and maybe Tarek can shed more light. I'm sure they do mediation courses as well, and may have, I think you did one with FIAC, didn't you, recently?
Yeah, SIMC, Singapore International.
SIMC, sorry. Yeah, so exactly. So I think, again, you don't need to go abroad. You can reach out to IAMC. Sorry, I'm not just saying it because you're on IAMC chat. It's just the easiest thing to do.
Thank you. Thank you, Arun. Thank you very much. Last question, Shruti. Shruti, we can't hear you. Sorry. Shruti, are you there? We'll skip Shruti. Manoj.
Tarek, may I ask a question?
Manoj wanted to ask a question.
Can I go ahead, please?
Manoj, right?
Yeah, this is Manoj, Tarek. Thanks.
Oh, hi, Manoj. Please go ahead.
Yeah, I actually belong to maybe a small community, though growing, of people who have been in the industry for a very long time, which is information technology, ranging from 15 to maybe 40 years, now wanting to pivot to the field of arbitration. I know there are several people, of that type. I'm curious to know in terms of what could possibly be done in terms of maybe lateral entries and things like that into law firms, or possibly how the wealth of experience guys like me have got can be utilized, for the betterment, because the disputes are getting more and more complex because of the way the technology is progressing by every day. This complexification will require in-depth knowledge in terms of the domain-centric knowledge. And therefore, I'm keen, and I believe this is something that's going to be very, very promising. And therefore, a pivot is absolutely great in the right direction. Happy to hear any views from Arun or Chintan or anybody else on that, please.
Bhushan, why don't you answer that question? Thank you, Mr. Mathur.
Cool. Happy to give it a swing. There's international arbitration, and then there's international arbitration, and then there's arbitration. Which is to say that you're right, that at its core, it is essentially trial lawyering, and it is absolutely essential to reach the kind of comfort that's required, especially with complex technical disputes. Now, I would try and say something that probably is a little controversial, and most certainly is against the grain. There isn't quite as much work to go around as one imagines. in international arbitration. And the community, if you have, and as I'm sure you have, tried to interact with them, is quite insular in its approach, and there are many potential reasons for why that's the case. It's essentially trust-based, because parties nominate their own arbitrators. They don't like to get too adventurous, let's say. At least as counsel, it has immense entry barriers. In no other area of law, in my assessment, will you find this sort of nuclear arms race where people speak 5 different languages, have 2 PhDs, qualified in 6 different jurisdictions, vying for an entry-level job, where you look at sort of stuff like capital markets. People sort of just straight away go from law school. We're all getting paid the same, and that's essentially because a lot of the work is by way of peer referral, and there, quite simply put, as I said, isn't quite as much to go around. The second thing I would say, therefore, is that there's a lot more work in my limited experience in actually domestic arbitration, and there is also a more sort of open textured culture, let's say, of nominating and appointing experts in as you might not be chair, but you'll certainly be co-arbitrator, and that, again, there are epistemological reasons for that. And that's probably because very often, at least with state contracts, you have engineers, for example, who are appointed as arbitrators in construction disputes and so forth. So I think there's more space there, and I dare say, is more opportunity there. But for international arbitration to pivot as an arbitrator without counsel experience is, I would say, difficult because of essentially trust issues. Entirely answers the question, but yeah, I have to stop here.
Thank you so much, Bhushan.
Sure. Thank you.
It just had one thing to add to that, to what Bhushan said. I think with your experience in your domain, trying to become an expert to assist in disputes, you might find a lot of companies interested in that. So you don't necessarily need to be an arbitrator. You could become an expert, and you might find that even more lucrative than being an arbitrator.
Thank you, Arun.
Thanks a lot. I think that makes sense.
Tariq, may I ask on the same line one question only?
Sure. This will be the last one, please. Yes, Vikash, please tell us.
Tariq, in India, we have a large number of guys having a good amount of experience in the domain, having finance and engineering background. Probably it is very difficult for them to venture into international arbitration, all those things, though they have a very rich amount of experience of that. We guys are training them to the extent they get to know the legal aspects, but yet it is very difficult to get attached, get the networking, and get attached with such kind of cases where they would upskill them or use their skill into that. So on the same line, I'm asking, what is the prospect actually, because it is very difficult, and especially to Arun, because he is also having engineering background. A large number of engineering graduates, which are huge amount, especially sitting in the PSUs and government setups. You cannot imagine the kind of skill with respect to the contracts and all things they are having and the kind of varieties they are having. But this is a difficulty if anyone could throw a light on that. And I am asking to all panelists, what would be the prospect and what would be the forum to reach out to that? Thank you, Tariq. Thank you.
Thank you so much. This was the last question. We won't be taking any question because I think we are about to exceed our time. Chintan, Arun, anybody can answer. One of you can answer, and we'll.
I think this sounds like it's right in Arun's ballpark. So I'm happy to leave it to Arun if he's happy to take it.
Well, you haven't left me a choice there. Okay. What I would say is 100%. I understand what you're saying, particularly in the construction field. There are plenty of people who get into engineering, from engineering, who then get into the field, who do contract management, who do quantum surveying, engineering, advice, etc. I'll repeat the same thing I told Manoj earlier, which is there's a huge market for becoming an expert in the field of international arbitration. If you come with a domain expertise which is unique, you will find that if you get into the right circles, you're automatically somehow, you will find that you happen to gain traction. Now, how do you get into the circle? It's not always easy, I fully agree, but there are professional organizations you could join. IAMC is one of them. The other one is the Chartered Institute of Arbitrators. There's the RICS, the Royal Institute of Chartered Surveyors, that's in the UK. Chartered Institute of Arbitrators is a good one. There's also Society of Construction Law. These are all professional bodies that are global. You could look to join them. Some of them are in fact free membership, not all. And the number of people of your similar background in those organizations is, you'll be surprised. I would say it's not all lawyers. It's a large number of people to expertise like yours. So you could then interact with them, network with them, and find out how they've tracked their career path. And that could be the subject of an entirely different webinar. And one probably I'm not at least as well equipped to speak to. So that would be my 2-minute answer to your question, but there are ways, and these are just some of them.
Thank you so much, Arun. Chintan, any last words from you?
I don't think I can add very much to that, Tariq, but I'd just like to thank you and the IAMC and of course all of my co-panelists. It's been a pleasure.
Thank you so much. So for me, it's been a very, very insightful session personally, to be honest, and I'm very happy that in fact, I got a lot of clarity, and I'm sure the participants also did benefit from this whole session. Thank you once again very much, each and every one of you, for taking out time. I know how busy you all are, each and every one of you, and it must have been really difficult to take out the time. But I really, really thank you on behalf of IAMC and all of us for enlightening us with these thoughts. And I'm sure many of us will be benefiting from these inputs that have been given today. And we look forward to other collaboration with you as well. So thank you once again, everyone. And I think now we can conclude the session. So I hope to see you all again. Thank you very much. Thank you, everyone.
Thank you.
Thank you.